necessity, not to do that. So this session is going to be a high-level overview. We're going to be using Maryland figures, and I know that at least one person on here is in Kentucky, and I will mention when the structure deviates for that state, but I don't know the particulars about each state. I do know Maryland, and I'm going to work from it. Each state is very similar, unless you're in New York or California, then you're very different. But is anybody here from New York or California? I see nobody saying anything raising, so I think we're probably good to go. So if you're not in Maryland, you'll get the concepts. If you're in Maryland, you'll get the concepts plus a little bit more detail. So without further ado, this is all about planning your estate, and it's an asset protection portion. But just remember, most estate plans fail because of neglect. And it's something nobody really looks at. When the actual point in time when your estate plan has to work is the time when the rubber hits the road. In most cases, it's going to be when somebody passes away. In this situation, it's going to be when somebody has a need to live in a skilled nursing facility. So we want to make sure that at least you get the message that whatever you do in your estate plan, whether it's asset protection for the potential nursing stay, or if it's just general estate planning, keep it regular, keep it updated, make sure that it's the latest and greatest, because you never know when the issues are going to hit. Why do we concern ourselves with Medicaid? So Medicaid it's a matter of people living longer, and there's not so many housewives and large families to take care of somebody when they get sick. You have the advent of two-party households. You have to have two incomes to support a household. And then people get stuck with kids, and they have to take care of that sandwich that they want up in. You've seen a proliferation of things like Alzheimer's and Parkinson's and ALS across the country. And the big fear for everybody is outliving their resources. Right. So how do you preserve your resources and take advantage of opportunities that are presented out in the world? Maintaining dignity, always think about dignity, passing assets to your family at your death, not using them up during your lifetime is a matter of dignity. I hear that an awful lot from folks. And, while a lot of people will be affected by long-term care personally, everybody will have some touch. Usually everybody knows at least somebody who is dealing with a long-term care kind of an issue. That's what this is talking about. This isn't the Medicaid, I'm down on my luck, I need health insurance kind of Medicaid. This is a long-term care. I'm at an end of life type of an illness, a debilitating illness, and how do I deal with these things? So just some perspective that in 1920, you were born, you had a life expectancy of 54 years. And in 2020, if you're born in 2020, your life expectancy is 77 years. Now, the irony is that 2020 was the COVID year, right? And 2019, it was a 78-year life expectancy, actually down 1 year in 2020. Imagine from COVID. And I pulled these off of the CDC website to get some perspective. So the average length of the lifespan is increasing, and the quality of life doesn't always keep up with the lifespan, and so a lot of these things need to be addressed. Who are the people that should target this? You have running your family, and you don't have a cognitive impairment. It's on my mind because my father died of Parkinson's, and so I'm always concerned about it within. And it's not necessarily hereditary. I did take a DNA test to determine whether I had a likelihood, and it came back negative. So, my father must have gotten it environmentally as opposed to genetically. So those are all ways to have a debilitating disease. But the longer you live, the more likely it is it's going to happen. So how do we deal with the costs? Well, what are the costs? So in Maryland, it's very common to see $15,000 a month in a skilled nursing facility. And I said source experience. That's what I hear, and that's what I see. when we're working with clients to get qualified for Medicaid. We're up to the 15,000, and it progresses each year. It doesn't go down, but it increases. So if you think about it, you map out 15,000 a month over the course of a year. That's breaking the piggy bank pretty much. Most families don't have the ability to self-pay. Ronald Reagan had Alzheimer's for 10 years and lived at home, and he had gobs and gobs of money to pay private nursing care, but that most of us don't have that ability. Where do we pay? Well, we wind up paying most out of the Medicaid world. So according to the Congressional Research Service, Medicaid paid 44% of the total cost of care, and the out of pocket was 21%. So, we didn't break it down into all the different aspects of it. And, there's always been a big push for long-term care insurance, and where the insurance winds up at 8%. That shows how much people are actually buying into that. There's more and more opportunities these days. So I will say that if you do not have an imminent need for long-term care, and you have the opportunity to look into either getting a life insurance policy with a long-term care rider or getting a straight long-term care policy with a or long-term care policy with a life insurance benefit rider, you might want to consider doing that because it can only help you tremendously in that regard. So I will say that's my piece. I'm not licensed to sell insurance, but this is one that I sell a lot of because it usually can make a very big difference in how much money people can save. And I'm talking tens of thousands of dollars, maybe even hundreds of thousands of dollars in the course of a stay in a nursing facility. Different ways to pay for long-term care. There's Medicare, so that's the other Medi. So the federal government is very good at trying to accuse people, so use very similar words for different programs. So Medicare is different than Medicaid, but Medicare will pay in limited circumstances for some long-term care. So we'll talk about that in greater detail. If you're a veteran and you meet the qualification to either have a compensation award or a Veterans Improved Pension award, then that can be applied to the cost of care. Long-term care insurance, personal assets, your family. Families get stuck paying out of their own personal assets when they sign the paperwork in the wrong way. And they sign as an obligor, they sign as a guarantor of payment. So if you want to, you're looking to this on behalf of another family member, you do not want to ever sign as the guarantor of payment because you are putting yourself and your personal assets on the line. You want to sign as the representative for the person. So you're signing on their behalf, but not signing on your behalf. So you want to make sure that's a distinction because there will be different ones on these contracts when you're dealing with skilled nursing facilities. And that's something that you really want to avoid. Most states have repealed their familial obligation statutes. So there was a case a few years ago in Pennsylvania where it was enforced, where the son had to pay the mom's nursing home bill under a statute that said that that child would pay the destitute parent. And I know Maryland, as soon as that case was decided by the Pennsylvania Supreme Court, the Maryland legislature repealed a similar statute in Maryland. So, and I think most states, those are common to the original colonies, but not as the states advanced west, they didn't carry those with them. And so right now, there's very few of those. They are books that are really enforced. And then Medicaid. Medicaid at the bottom of the list because it is the source of last resort. And that's something to always keep in mind. Medicaid, not Medicare. So Medicaid is what we're talking about. So Medicaid was created in 1965 under the Great Society. And it is a jointly funded program by the federal government and the state government. So for every dollar the state spends, the federal government matches. So it's a dollar for dollar set off. Federal government is the one that sets the guidelines. So they set the overall law as far as the Medicaid long-term care. And then there's leeway for the states to decide what details are and how to apply to them, which is whether you can have different requirements in different states. And so it's just, okay, state, you pick and choose how you want to address these things, but there's certain things that you have to follow, everyone has to follow. So I usually like to say that the federal government provides the skeleton, and the states, they create the fish on the bones, so to speak, and that's why they're all different from state to state. And sometimes within the state, they're different. So different areas of different states. I mentioned New York at the outset. New York, each borough of New York has a different set of rules. So it's in New York City. So it's really weird the way it's set up there. It is a welfare program. So it's technically, that's what it is. It's a payor of last resort for the indigent. All right. So you have it's not health insurance, but there is a Medicaid component that is health insurance. But what we're talking about is the long-term care benefit. So there's a little bit of different qualifications. And it gets confusing. I'm open up the fire hose a little bit here and maybe confuse folks a little bit. There is a Medicaid component that is health insurance. We're talking about qualifying under long-term care. But anytime that you do qualify under long-term care, you get the Medicaid health insurance no matter what. So it does wind up back in, but we're only concerned with qualifying for the long-term care and taking care of that $15,000 a month bill. So it is the only public assistance program to pay for that type of care. So and they do crack the big nut on this. So let's talk about how Medicare pays. Medicare will pay to a certain extent. So there's a 100-day rule. So for the first 20 days inside of a skilled nursing facility, that's the new name for a nursing home, right? So the first 20 days are 100% covered by Medicare if you meet certain criteria. The next 80 days, it's partially covered. So you have, as a family, you have a $204 per day copay. Now you may have insurance that covers that as well. So you might have a supplemental insurance, and that would pay that $204 a day. After 100 days, there's nothing to be paid. So 100 days, you're done. Then you've got to figure out a way to pay. If you're in a skilled nursing facility, you will generally get a status meeting somewhere around the 15-day mark. And that's to determine type of care is continuing to be needed. Why? Because some of the qualifications are that the demonstrated stability, that the person is stable, they're not regressing, so they're at least maintaining their status, and they require skilled care to do so. So there's your requirement. You need some type of therapy, physical therapist, some kind of in that regard. That's usually what it is. It's a physical therapist to help people move around and eat and communicate, get dressed, and all those kinds of things. But before Medicare will pay anything, how you get to the facility is most important. So Medicaid payment doesn't kick in unless you go to a hospital first and you're admitted for 3 overnights. So 3 overnights in a hospital, and then you're transferred to the skilled nursing facility. Then Medicare pays that first 20 days. As long as you're getting skilled care, you can demonstrate that your condition is stable. It used to be that you had to improve, you had to show continuous improvement, but that changed about 10 years or so ago. And so now it's demonstrated stability. On average, you're probably getting between 20 and 30 days of benefit because one of those drops somewhere along the line. And then your family has to think about where the payment comes from, because you get a notice that'll say that so-and-so is paid until this particular date, and after that date, you have to find a way to pay the bill going forward. eligibility criteria. There's the medical and income and assets, but there's also the personal stuff. There is a requirement that you be 65 years old, or if you're less than 65 years old, you have to have a disability. And a citizen or permanent resident alien. So if you just crossed the border and are waiting for your hearing and something like this happens, you're not eligible for Medicaid. But if you have a green card, and or you're a citizen, U.S. citizen, then you're good to go. And you be a resident of the state in which you're applying. So I have Maryland because I'm in Maryland. I'm an attorney in Maryland, and I know that that Mark is in Kentucky. So for a resident of, if you're applying in Kentucky, you would have to be a resident of Kentucky in order to get those benefits. And how do you become a resident? The easiest way to prove residence is to get a voter ID card in that particular state. That's usually the thing that is most widely accepted. But it's very easy. There's no waiting requirement. You don't have to live there 6 months, or anything like that. It's just you have to establish an intent to permanently stay in that state. Medical, you have to have need the level of care to reside in a nursing facility, skilled nursing facility, nursing home. And there's income restriction and there's an asset restriction. So and these are treated differently in some ways, whether you have a spouse or whether you're a single individual. So the three issues that are most commonly addressed in Medicaid qualification is the medical requirement. So there are things, activities of daily living, and these 5 are up on the screen. So you have to be unable to perform 3 of the 5 in order to qualify for immediate care and with a Medicaid level of payment. So what has to happen is the facility where you are has to certify that you are unable to perform 3 of these 5 activities of daily living. Doesn't matter which ones. If you have full-blown dementia, then it's pretty much deemed that you can't do these things by yourself. But by and large, these are the things, the ADLs, and this is the medical requirement. So when people start to become, they got to understand how these work sometimes when the applications come through. When people start qualifying, more people start qualifying financially, then they look at these medical requirements with much more scrutiny, and they make sure that the T's are crossed and the I's are dotted, and to verify that folks really do meet this level of care. So, couple of vocabulary: applicant or applicant recipient. I've used applicant a couple times. Applicant is the person who's ill. So they're deemed to be the applicant for benefits. Now, they may not sign the application. So a spouse or a child or a close friend or relative who's helping the person, they may sign on their behalf. So, but the applicant is the person who's sick, the person considered to be applying, and be the ones who would be living in the nursing facility. And if they're married and have a spouse who is okay and they're just living their normal life, that spouse is called the community spouse. So if you're ever doing any reading and you see things, references to community spouse, that means the spouse living out in the community. So the interesting thing is that community spouse was really thrown under the bus from 1965 to 1988 when they enacted the spousal impoverishment rules in 1988 to prevent the spouse from going broke. But now it's a much more benevolent qualification. It's not ideal, but it's much more benevolent than it was. So income eligibility. Well, there's 2 types of states. There's an income cap state and a non-income cap state, and the qualifications are different depending on which type of state you're in. So I live in Maryland, and Maryland is a non-income cap state. So if the monthly cost of care in the nursing home is $15,000, then in order for me to qualify to receive benefits, my income must be less than $15,000 a month. So that's pretty simple. So in an income state, my income is capped for qualification at $2,129. It's quite a difference from 15,000, isn't it? So this is an area, Kentucky is an income cap state. So if a resident of Kentucky is applying for benefits, they're going to have to deal with the income of the applicant a little bit differently than the way we do here in Maryland. And most likely they're going to have to create what's called a Medicaid income trust. It's colloquially named as a Miller Trust. So that is something that has to be created to collect income that is over the 2829. So if somebody is making $3,500 a month in income, well, then they've got about $700 they have to collect through that Miller Trust. And it's a shell. You're just shuffling from one to the other. And to me, it really makes no sense as to why they do that. It just creates extra tasks. At the end of the day.
So Ed, real quick, does that include Social Security and income?
Everything. It includes everything. So here's the next slide, George. Income includes pensions.
Looks like I read the slides.
Interest, dividends, income from joint assets, alimony, support, PA pension payments, rent income. So everything you can think of that's income from all sources derived, as they like to say in the Internal Revenue Code, that's what it is. And when they do calculate income, they calculate gross income. So they add back all withholdings and they say, hey, this is your income for the purposes of Medicaid. And so it is all inclusive of the income. So the individual applicant, their income is supposed to go to pay for the cost of care, which is why if I make more than the cost of care, then all of my income goes to pay the cost of care and covers it. So I don't have to, I can apply for benefits. But income cap state, it's a lot different. So you have that Miller Trust aspect to it. And then this is what you consider. So all these things add back to withholdings for insurance, for taxes, all that stuff gets added back in. And that becomes the income and see where you qualify. And if your gross income exceeds the 2029, then you have to take those extra steps associated with getting the income under control. It's not difficult. It's just a pain in the backside to do that. It's just extra stuff to do. So it can easily be done. So I don't want to give the impression that you're climbing Mount Everest to do the thing. But it's just extra speed bump that you have in those states. So they're very inclusive. They sweep everything in as much as they can and all the withholdings as well. So what about the community spouse? So we know the applicant has to pay their income to their cost of care, but the community spouse, they might need some of the applicant's money in order to keep their bills paid. And so the law recognizes that at a very minimum, they need $2,555 a month. Now they may need more. So there's a way you submit a worksheet that shows this is all my monthly expenses. And if it's more than $2,555, so we're actually working one where there's the husband makes $5,300 a month and the wife makes $700 or $800 a month. So at a minimum, she gets to take enough of his herself so that her income totals $2,555. So if it's she would get to take $1,700 roughly for round numbers. She gets to take $1,700 a month off the bat, no matter what. If she has additional expenses that go beyond that, then she has the ability to do that to $3,800 and $3,800 and something. I don't remember what it is, and I didn't put that on the slide. But that's called minimum monthly maintenance need allowance. There's a maximum for that benefit. However, if the community spouse was making $5,300, there would be no issue because the community spouse's income does not do anything to disrupt the application for their sick spouse. It's only when the community spouse's income is low that they can draw from the applicant's income. but the applicant is not ever drawing from the community spouse's income. We did one of, I guess it's about 7 or 8 years ago, where the community spouse had an income of about $7,500 a month, and she wasn't applying. Her husband was applying, and so she got to keep her $7,500 a month income, and you only work off the applicant's income in regards. So there's ways that the spouse is protected. This is one of them. So the income doesn't get factored into the application process unless it is very low. Then they can draw from the applicant's income. Assets. This is different. So the assets of the applicant in Maryland cannot exceed $2,500. Now, in most states, it's a $2,000 maximum. In some states, it's more. So it all depends on where you are. But in the great majority of the United States, it's a $2,000 maximum. It's been adjusted more. I mentioned New York before. New York is off the top. New York is, I figure, they're like $10,000 to $13,000 is what the asset caps are. Now the community spouse, they can have as much as $154,140, and these numbers change. The 2,500 hasn't changed as far as I remember in my career since I've been doing this. So that's been pretty much the norm throughout. Some states have increased. I know Missouri in the last several years increased theirs past the 2,500. They used to be, they were at one time, I think $999 was theirs, and they increased it, I think, to at least 3,000, maybe more. Yeah. But the assets of the community spouse can't exceed $154,140 if the application is being filed in 2024. So this is a number that is set by the federal government. So the community spouse number is set by the federal government. The states decide how to apply it. Let's talk about how this works. There are two types of assets. There are exempt assets, which are ignored in the application, and there are non-exempt assets that are considered countable resources to pay the cost of care. So the first exercise is to figure out what is exempt from the application process. And so the exemptions are the equity in the home, and in Maryland, it's the full $713,000 of equity. In some states, it might be less. So that's one to check. I do not know what that number is in Kentucky. So sorry, Mark, I don't know that one. But there is vehicle is exempt, so it's very common. So one of the things that we advise clients, especially when there's a community spouse, is that when it's time to apply for benefits, buy a new car. That's a legitimate expense. And if you have an older car that you're really fond of, but it's got it's at least 10 years old, you might want to just get a new car that has a warranty attached to it, and that maybe they have the services, the maintenance schedule is included. You can do all that stuff, and you can have a much better ride, and you have a much better ability to take care of if any kind of issues arise in the car. So I put Rolls-Royce up there because it's an extreme example. Could you buy a Rolls? You might be pushing it with a Rolls and spending a couple $100,000 when you don't usually do that. But there's no reason why you can't buy a $60,000, $70,000 car if you want one, because that's what a lot of cars cost these days. So that's always a possibility. The home is exempt, so you can make home improvements. Those are also valid expenditures, and there's no reason why you should live in a home that has a 1950s bathroom because you're saving money, and you're going to have to spend it on the cost of care. You might want to call out for Medicaid and a new bathroom at the time. So who knows how that would play out. If you're selling real estate, selling your house, and you're not married, so you're in the nursing home and your family is selling the house, that's considered exempt as well. And then there's income producing property. So if you have commercial property that you or rental properties, those considered income to you, not considered assets. So in other words, your income that you receive from that will be counted under the income column, but the value of that property will not be counted as an asset. They don't double dip like that.
So Ed, when the real property sells and there is a chunk of assets, is that still exempt?
Good question. So you sell the real estate in September, then that check you get at the settlement table is income in September. The question is, what do you do with that before the end of the month? Because the way Medicaid rolls, they roll on the transition to each month. So as long as you're in September, that's income. And then you have an opportunity to take that income and create an exempt asset out of it if you can. There's ways to do that. You could create a Medicaid compliant annuity that would, and has certain requirements, and then that would all of a sudden take that off of the table. What we do often, because the that Medicaid compliant annuity requires a payback to the state for payments made, what we would generally do in that circumstance is we would do a calculation to figure out how much of those proceeds can we transfer and create a penalty. How much of a penalty can we stand and still have enough cash left to cover that penalty that the state is going to give us? What that will do is that will allow us to create a trust for that particular amount. So let's say it's $500,000 we sell the house. Maybe we can put 250 grand in a trust and then spend 250 grand to cover the penalty period. So out of the 500,000 we got, we're at least able to save a portion of it and not continuously pay and go forward. We can still qualify. What I'm saying is that you protect it, and then you can qualify for the benefits. And it's a very great, it's a real cool technique to use, and that's very common one that we use in our practice, is using a combination of a trust and the Medicaid compliant annuity in that regard. So yeah, the real estate listed for sale, and that's you get the dichotomy between an asset and income. So if the income stays in the account and you cross it to the next month, then it's considered an asset, and you're going to be past that 2,500 at that point by having that in there. But as long as it's in the same month and you're manipulating it into something that's considered exempt, you're able to make it work and not have it count against you, or you purposely count it against you for a very limited amount and have enough offset to cover that penalty. I'm going to get into the penalty in a few minutes. So, but that's pretty much, we've exhausted the exempt. Everything else that you have is considered available to you. So I mentioned before that spouse could keep 154,140, and that's true in some states, but most states are what we call a range state. So the applicant gets to keep 2,500 in their own name. The exempt assets are off the table, and then all the other assets, all the other assets, 1/2 of it can be kept by the community spouse, subject to a minimum of 30,828 and a maximum of 154,140. This is the rule in Maryland. So Maryland is considered a range state. So if you have $25,000 outside of the house and the car, and your spouse gets to keep it all. If you have 300,000 outside of the house and the car, and so out of the exempt, non-exempt property is 300,000. Well, then your spouse gets to keep 154,140, and they have to spend the other 140,000 that some change in that way. So that's how it works in most states. I know Let me think. I think Texas is one that has a maximum, uses just the maximum. There's a couple states out in the West that more Western do. The Eastern states really just try to soak you, I think, more or less along the lines. Anything that you receive a service or you receive a good in return is a legitimate expense to pay. And when you're buying things like a prepaid funeral contract, and you know, you can uh, you can spend that money and not have any issues come back at you because that is a legitimate expense. The thing that you don't want to get caught doing is spending all your money and then not having money to pay for a funeral. So you do that in advance. That's part of a legitimate spend. So spend down simply means that you're buying things for which you get like value in return. You're not just giving it away and saying, "Hey, look, I'm now a pauper. I need to have somebody pay for my cost of care." That's what they don't like, and they will investigate that as well. So, recap: the community spouse assets can exceed 154, 140. This gets bumped up each year for inflation, but in most situations, especially since I'm in Maryland, I use the range. But it's after excluding the exempt assets, one half of the remaining assets has to fit into that range between 30,828 and 154, 140. So if you have 35,000, you get to keep 30,828. You spend 4,172 is what you'd have to spend. So that's kind of the way they work. It's pretty straightforward in that regard, but it's not so straightforward when you're looking at it the first time. So we use spreadsheets and to compare, and just to remember, putting your son or daughter's name on your bank account does absolutely nothing. So it doesn't prevent anything. In fact, it probably just introduces more wild cards to the situation. Anytime your name is attached, if you're applying for Medicaid, your name is attached to an account of any type, then 100% of that value of that account is presumed to be yours, unless clear evidence is presented to show that someone put money in that account. So putting somebody else's name on convenience does absolutely nothing. And so don't fall into that. I hear that a lot, but that is not something that will get you very far. It will just gum it up and make it more difficult for you to fix it afterwards. So a lot of folks have heard things called look back period. So they look backwards, apply, look backwards over a period of time to see if you've given your assets away in order to qualify for benefits, because that's a no-no. So they want to make sure that you didn't do that. So how this works is that when you are in a nursing home, you qualify weekly, so you have the three activities of daily living that you need help with, and you qualify financially, both income and assets. And then you apply when all four of those conditions are true. That's when they look backwards. So when let's see, my all right, there we go. In reality, it's simply on the date that you file the application, because in order to file the application, all those other conditions must be true. So they look backward from the application date. Today is September 11th. So if you file an application today, it would be filed as of September 1st. Every application is filed as of the first day of the month in which it is filed, unless you elect to go back 90 days prior. So you can go backwards up to 90 days. So we could go back to June 1st if we wanted to. As 90 days is, so that's 1, 2, 3, yeah, 90 days would be June. And so they look back 5 years under the Deficit Reduction Act of 2005. That was increased from 3 years to 5 years in 2005. And so look back to see what you've done. So if you have gifts called uncompensated transfers, we call them disposals for no value is what the technical reference is. So it's regardless of the purpose. Somebody got married and you made a large gift. You gave somebody 10,000, 20,000 to help buy a house. It doesn't matter. That is presumed to be done. If it's done within 5 years, your application is presumed to have been done for the purpose of qualifying for benefits. It is subject to a transfer penalty. If you give large gifts to charity, then that it doesn't matter how big of a heart they have, but this matters that transfer is made, and you have to account for that.
So when you make a charitable contribution, let's say you to your church on an ongoing basis, and then you get sick or something and you have to apply for the Medicaid, and they say that, so you have to be accountable for that. What does that mean? Claw back from the charity or what?
Yeah, no, what that means is add all those up and determine what the total value is over the last 5 years. And then they do a calculation. The calculation's on the next slide. But what they're not going to do, look, I mean, if you're just giving a tithe, you go to a church, put something in collection plate every something like that. That's not what they're going to come after. They're coming in larger transfer. So they're going to look for something that's more than $1,000. So if you regularly give $1,000 gifts to the church, well, then that's something you might want to think about. How do you do that? How do you want to handle that? And it may be that as they go up in time throughout time, that number will increase to a large number. But right now the rule of thumb is that you keep your donations under 1,000, you're probably going to be okay, because they're not going to look at that because there's just too many things are costing that much money, and it's too much to chase for the qualification. But that's why if you're doing something that's large, you're having a big campaign to build a new building or a school or something like that, and you make a large donation, and then you have a stroke and you go into the nursing home, that could come back to create a problem. Don't know much of a problem. It all depends on how much you give. So you're also looking for sources of income. So if your older statements show an income source that your newer statements don't, then they're going to look for an explanation as to what happened to that income source. So that's something that they do float through. So they're looking to limit the state's liability to pay. They're looking for reasons to lower what the state pays, because the state pays the full amount minus the applicant's income. So they're looking for income sources for the applicant to try to defer the state's obligation. So what happens if they find these things? Well, there's a penalty for asset transfers for full value. So the penalty amount in Maryland is based on a monthly divisor of $11,513. So this is the state's assessment of what the average cost of care is in the state of Maryland, and it's always less than reality. So the daily, there is a daily component of this. So, and I didn't write it down. In Kentucky, they don't have a monthly divisor; they have a daily divisor, and so the daily divisor in Kentucky is somewhere around $300 a day. It's easily Googleable, and that can tell you. So, and what we do is we take a look at all of the assets that were transferred for less than full value over the prior 5 years, and we divide that by 11,513. So, for example, if we gave away $115,130 over the past 5 years, divided by 11,513, the product is 10. That means 10 months penalty, meaning the state will refuse to pay for the next 10 months. So you have to find another way to pay the cost of care. So what we do as a law firm is that we will analyze these numbers and determine how much can you give away still have enough left over to cover whatever the penalty period the gift creates. And so we often hold it in trust, and it'll be a gift to the trust. And then the amount that's not gifted gets put into an exempt asset, which would be the annuity, the Medicaid compliant annuity. And so therefore, we qualify for the assets and qualify for the income. And when we have this penalty assessed, we'll have this source of funds to cover that intervening. If it's 10-month period, that'll pay for the 10 months. The most recent one that we had a, it was interesting because I calculated a 13-month penalty period, and I in the application letter I said that we're expecting you to calculate a 13-month penalty period. Calculated a 12-month penalty period. And I said, well, I'll take, if you do that for 12 months. But we had plenty of money left in the annuity to cover that period of time. And Mom was able to save. We were able to save just under $200,000. It was a $400,000 state. So we were just under the $200,000 mark. There is, and so she was able to qualify in a year as opposed to having to spend all our assets first. So the graphical way to look at it is that if you look backwards over your application date of today is the application. So 1 year ago, 2 years ago, 3, 4, 5, that's what's in play. If the transfer occurred after that 5 years, so then you're good to go. So sometimes when someone comes in and we're doing an analysis and we're looking back and we see that you're at 4.5 years, again, this big transfer made is to create the penalty. Well, maybe it makes more sense to just delay the application date 6 months and just pay out of pocket for that 6-month period, and you eliminate that penalty going forward. And so if the penalty generates a 12-month penalty period, then maybe it's better off to just take that 6 months and go at the prime rate and at the personal pay rate, and then go. So the question is always about how do we give things away? No 10,000 annual gift exclusion for Medicaid. There is an annual gift exclusion for federal gift tax. It's 18,000 this year, but that's a question that we always get, and so can't mix our body of law. Medicaid is separate from the tax. They are apples and oranges with that. So our look back is important to determine whether there's going to be a penalty or refusal to pay by Medicaid, and we need to know all the stuff up front so we can analyze it properly and make any adjustments as to how to proceed. So as many solutions are available, but planning in advance creates the most savings. I'm an advocate of long-term care insurance because when you have long-term care insurance, you employ the strategy that I'm talking about today, then when you have those two together, then the percentage of assets you can protect is much greater. So instead of being just under 50%, we can be 60, 70, 80% of assets and still have the individual qualify in a short period of time. So without spending all their assets. So it's countable assets are often used to buy exempt assets. So that's our first step. And being proactive is always the key. The sooner you go, and look, here's the example. Everybody drives, right? You're driving the road, you see the speed limit sign, you see you're going about 20 miles an hour speed limit, and you have a choice. You can either back off and slow down, or you can just continue on your way. And if you get caught, there's a police officer up ahead, and you didn't slow down, well, then it's going to be a bit more expensive for you than if you had been proactive and taken the foot off the gas. So the same principle applies. I don't have an evaluation as I usually do. I'm sorry I didn't take that out of the slide. But if you want to learn more, you can certainly follow up individually. We've reached the end of the session, so we're just under an hour. So I'm happy to take any questions, concerns, whatever you would like to do.
Hey,
here, or we follow up. You can follow up personally if you choose.
Ed, can you hear me okay?
Way you are. Actually, I can hear you better now than I have the whole time
Okay,
today.
good, good.
Ha.
Um, first of all, for everyone on the call, Ed is excellent, excellent at this. We work with Ed a lot. Highly recommend reaching out to Ed if you need help with your estate plan. Ed, I wanted to review the community because this is a common one George and I get. So you have a husband and wife. One of the spouses needs nursing home care. Okay. The community
Yep.
spouse, let's say there's $1 million in assets. The community spouse is the breadwinner and has the IRA that's worth $800,000. Okay. Is their IRA protected? The community spouse.
So you've touched on one of those issues that varies from state to state. So for Maryland residents, state of Maryland views IRAs and other retirement plans as completely available for the payment towards cost of care. That's both spouse and the applicant. So community spouse and applicant. So Maryland has a very draconian rule for that. And so what happens in a lot of those situations is that people will invest their IRA into a Medicaid compliant annuity, which will then make it exempt. The problem is that one of the things that makes those compliant is that it accelerates the payout. So if you're 80 years old and you have an 8-year life expectancy, that has to be paid out in 8 years.
Right.
And by the way, if you die before the 8 years is up, the first beneficiary has to be the state Medicaid agency to pay back what they've paid. So there's shortcomings in that regard. I believe the state of Pennsylvania allows the spouses IRAs retirement plans to be protected. And if I'm not mistaken, again, Mark, you can follow up with me directly because I can help you there. But I think Kentucky does as well, if that even applies. States like Florida, I do know Florida, if you are receiving required minimum distributions, then it's considered exempt. The asset is, but the income is considered income too. The RMDs are considered income. So each state deals with them differently. And unfortunately, in Maryland, where we are, it's the most draconian way
Right.
that they view them.
Awesome.
Yep.
And then
Got a couple questions
wait,
here.
hold on, George.
Okay.
1 sec. So and then with a house, if the couple has a reverse mortgage on the house, I know a house equity in a home is an exempt asset, but if you have a reverse mortgage and income coming in from that house, is that counted?
Well, if you have, so here's the first thing you want to consider is that only matters if the check is payable to the applicant spouse. So if the community spouse, so what happens in a lot of situations is that for folks who don't have a lot of money to begin with, there's a community spouse. We'll often talk to them about, maybe you create a reverse line of credit so that you can tap the equity as you need it going forward and not have to worry about paying bills and things of that nature. So that's usually a very utilitarian for folks. But if you've already created an obligation during the lifetime of, if both spouses together created an obligation before there was a nursing home circumstance, that becomes a bit more problematic because one of the things you have to do is move the house out of the applicant's name and into the community spouse's name alone. And to lien on it create a problem for that. We would need to get the consent or the acquiescence of the lien company, or if you have a new lender that would lend to the individual based on a reverse mortgage proposition, then we could refinance that way and do transfer. So yeah, there's the reverse mortgage is a utility. You want to use it the right way and for the right reasons.
Right.
Remember, there's always a state recovery. They always try to recoup their losses by putting liens on things. And if you're using the equity in the house, they can match the house, but they would be in second position behind the mortgage company. And so once the house would be sold after your death, then the mortgage company gets paid first, and to the extent that there's anything left over, then the state would be second in line in that regard. But they're supposed to do that. And here's an interesting twist. I did have the head of the Maryland. This is 8 years ago. So the head of the Maryland estate recovery unit of the Medicaid agency. So she was an attorney I knew in law school. And she came to me to create trust for her parents so that there would not be any probate assets for the estate recovery to come after if our parents were in the nursing home. So people are aware of it, and it's generally non-probate assets are exempt. If there's a rare exception in some cases, I know in the state of Idaho, there was a case that held that the estate recovery could apply to non-probate assets, but that's the only one that I'm aware of. That doesn't mean that I know every state or anything like that, but that's what jumps at me.
Yep.
We have a question. If someone has Medicaid now, do they need to apply for Medicaid long-term care separately?
Well, if they have Medicaid health insurance, you mean?
I believe so.
So I don't think, yes, you do have to apply for long-term care separately. So if you're, because the Medicaid health insurance not pay custodial care. And so custodial care means that taking care of you for things like helping you eat, helping you get dressed, helping you get bathed, and those kind of things. That's custodial care. Medicaid health insurance are paying for doctors and skilled people who are helping you. So they're separate and distinct in the process of applying and qualifying for.
Okay. Does a divorce settlement and division of assets within a look-back period affect application?
Say that again?
Let's say someone gets divorced
Uh-oh.
and there's a division of assets within the look-back period. What happens?
It's a court order, so it's not an issue. It doesn't interfere. So they follow the court orders. So it's not them. It's not somebody trying to purposely become indigent and qualify that way.
Let's say a grandparent has a 529 for a kid, and there's a $6,000 in the 529. With the look back period, the grandkid goes to college, spends the money. Does that impact anything within the look back period?
That's a good question. I've never come across that in a Medicaid application. So I'm not sure exactly how that would play out. Because those are structured to benefit for tax purposes. My gut tells me that it would be considered a transfer because with a 529, if there's money in the account, you could pull back without penalty. So I think it would probably count as a countable asset. And if it was used to pay tuition, then it's possible. I don't know the answer, so I'm just running off the top of my head as to what might. So don't take that as possible or anything, but just doing a quick analysis. So I really don't know the answer to the question. It could possibly be that there's a rule that says otherwise. So now that you brought that up, the first thing I'm going to do when we end here, I'm going to pull out the Medicaid manual and look for 529 plans and see how they address them.
Okay, I think that's about it. We're out of time. If people want to stick around and have another specific question, please do. Thank you for your time. We want to respect your time, everyone else's time. Thanks a lot. Look for us next time. We can take recommendations for topics. We're happy to entertain different topics. You may also give us a call directly you have any questions specifically about finances, estate planning, and or retirement planning. Okay.
Thank you very much, folks.
Thank you. Have a great day.